with office of profit. Now, to be fairly clear, office of profit has never been asked in the mains exam ever. But it is also one of the reforms and one of the ways in which one could have a better functioning parliament. So therefore, a brief idea about what office of profit is more than essential. And when we cover office of profit, we should barely be answering four questions. One, what is the concept of office of profit? Two, what is the rationale behind it? Why was it even formulated in the first place? Three, what are the essentials and the tests which are largely laid down by the Honorable Supreme Court when it comes to the office of profit? And four, how do we make the office of profit better? Now, the idea goes back to our forms of government before we get into the concept of it all. The idea is actually a largely simple one. On the one hand, we have a presidential system of democracy. On the other hand, we have a parliamentary system of democracy. A presidential system of democracy is largely based on the principle of, which is far more important to the presidential form, is stability. Whereas a parliamentary system of government tends to give more emphasis to the principle of accountability. So when nations all across the world are choosing between a presidential or a parliamentary form of government, they're effectively making a choice between being more accountable or more stable. Now, this decision therefore will have a direct impact on a larger constitutional principle called separation of powers. And the two most important areas where there must be separation of powers is perhaps between the legislature and the executive. And by the executive here, we are referring to the elected executive, which is basically the ministers. Now, in a presidential system, the separation of powers seems to be in a far better position because the head of the state and the head of the government is one person and is functionally distant from the legislatures. But in a parliamentary system, the ministers are collectively responsible to the lower house, and you can only get to be a minister if the political party that you come from enjoys a majority in the lower house, and the parliament as a whole also gets to keep a sense of accountability and also tends to keep a sort of check on the executive through motions, debates, discussions, votes, etc., etc. So one can safely say that the doctrine of separation of powers is far more solidified in a presidential system and is far more diluted in a parliamentary system. Now, whenever there is a degree of intersection, it leads to an age-old principle of governance which must be avoided at all costs. This age-old principle of governance is called conflict of interest. And conflict of interest seems to be one of the primary problems every governing authority at some level or the other in the world wants to solve. And this conflict of interest and the prevention of it is why you have the concept of office of profit, which is therefore an extension of separation of powers. And once we understand the context in this right, we can therefore move to understand the ingredients around it. Conflict of interest is something that you would be most ardently quoting in your paper for answers. Because conflict of interest is directly related to integrity of service, is directly related to the honesty to which a government official or any person in a position of authority is supposed to exercise her responsibilities. So therefore, one can very categorically say that office of profit is a juxtaposition of conflict of interest and separation of powers. And once we have that sort of a clarity in place, one can therefore move to our very first question, which is, what is office of profit? See, in the introduction itself, I've given you certain categories of introductions. If it is a smaller 10 marker, just an introduction which reflects the meaning in a rather simplified form has been given to you. Very simply put, office of profit is nothing but a disqualification criteria for our members of parliament and the members of legislatures, which can be exercised by the president or the governor on the binding advice of the election commission. An office of profit is therefore mentioned as a disqualification criteria explicitly in the constitution. And in fact, it is an original part of the constitution. So therefore, the question becomes as to what is office of profit. See, an office of profit has often been interpreted to simply mean a provision which brings the occupier of that office, the occupant of that office, some form of gain, some form of additional benefit which is uncalled for. That gain could be financial, it could be pecuniary, it could be any form of an edge. It doesn't matter what the quantum of that gain is. The problem lies with the fact that there is a gain. One must also understand that per se, office of profit is not a problem. The problem is if you hold another office of profit. Because the literal meaning of office of profit is that anybody in the government who's working for a certain consideration, and technically everybody in the government works for a consideration, everybody gets paid. The problem is not that you get paid in the government. The problem is that if you get paid from two places in the government, if you have two government positions, if you have two government jobs, so that's the rationale behind it. So one must not always have a negative connotation to what is called office of profit. Now, as I was mentioning before, office of profit is explicitly mentioned in the constitution. And in the constitution, it is explicitly mentioned under articles 102 and 191, where an MP or an MLA, also by extension a member of legislative council, is barred from holding any office of profit under the central or the state government. And within the constitution as a proviso it is mentioned, unless they are ministers. Because sometimes it is constitutionally compulsory to hold two offices. Because we are a parliamentary system of government, ministers, if not at the time of appointment, but within 6 months have to be members of parliament or state legislatures, whichever the case might be. Because that is the basis of parliamentary democracy, otherwise we would have become a presidential democracy. So if we are a parliamentary democracy where the ministers have to be members of the house eventually so that there is greater accountability, then technically the same person is a minister and a member of parliament. Now, if the same person is a minister and a member of parliament, technically there are two offices. But the same person holding those two offices is absolutely necessary to uphold the principles of parliamentary democracy, to uphold the tenets of parliamentary democracy. And that is why office of profit per se is not wrong. It's the abuse of it which is a problem. Now, the idea is these provisions of Article 102 and 191 can also be protected by certain exceptions. The principle of law is there is nothing called an absolute law, which means that technically you cannot hold any other office of profit unless the other office that you're holding is also exempted under law. And technically there is no bar on the number of offices that can be exempted under the law. And in the recent past, several state legislatures have been in the news for several reasons because of office of profit, because of an office that they created to the tune of parliamentary secretaries. In fact, very recently in Delhi, 20 MLAs of Delhi were disqualified on the grounds that they were holding the position of a parliamentary secretary to the minister. The idea is you cannot be disqualified, you can be disqualified for office of profit unless that office is exempted under law. And several state legislatures have enacted such laws, and the parliament also has enacted a law which is called the Parliament Prevention of Disqualification Act of 1959. And this Parliament Prevention of Disqualification Act of 1959 is primarily based on the recommendations of the Bhargav Committee, whose primary job was to examine as to why such instances were even reported in the first place. Now, the principle is the same. If you look at it in terms of structure, office of profit is functionally similar to immunities and privileges. While the Constitution tells you the kind of immunities you have, it doesn't define what those immunities are. In the same way, while the Constitution mentions the word office of profit, but what is the exact definition of office of profit is nowhere mentioned in the Constitution. And when the Constitution misses to define such an important word, it is only eventual that the judiciary will step in and will lay down certain guidelines and certain tests. The parliament has listed a set of offices which are exempted from office of profit. Understandably so. But still, what is the definition of it is still problematic. Now, if you go back to the parent diagram that we were looking at, when office of profit simply becomes a confluence of conflict of interest, where a person cannot hold any other government office, this is also to uphold a larger issue of political opportunism. Because if you remember carefully, and this is where it gets very interesting, if you remember carefully, when we studied anti-defection law, we had given a reference to the 91st Constitutional Amendment of 2003, which restricts the number of ministers that can be appointed. And ordinarily, you have 15% of the strength of the lower house, which can be the total number of ministers. The ministers can come from either houses, but the total number of ministers that each layer of government can have is not more than 15% of the strength of the lower house. For example, at the central level, you cannot have more than 81 ministers. That's the larger principle behind it. Now, if you cannot have more than X number of ministers, and let us say you are looking at a coalition government where certain aspirations of your parties have to be managed, have to be adhered to, but you cannot appoint more ministers, then office of profit simply becomes a bypass to this rule. While we cannot make you a minister because of constitutional restrictions, but what we certainly can do is give you a position and exempt that position under the Parliamentary Disqualifications Act of 1959. In fact, for example, chairpersons of most vulnerable section bodies, so your National Commission for Scheduled Caste, Scheduled Tribe, Backward Classes, minorities, if I remember correctly, they're all in this Parliamentary Disqualification Act, and these are all exempted offices under office of profit, which means a member of parliament can also be the chairperson of the National Commission for Scheduled Castes, and that is an exempted office under the Parliamentary Disqualifications Act of 1959. That's the basic law. Now, this also becomes a larger issue of something that we studied in a tangential manner called the doctrine of colorable legislation, which means what cannot be done directly must also not be done indirectly. In fact, under the Parliamentary Disqualification Act of 1959, your leader of opposition, your offices of whip, chief whip, these are all exempted offices as they also enjoy certain equivalent statuses. Moving on, we also therefore understand that office of profit is directly correlational to majoritarian governments. In fact, is inversely proportional to majoritarian governments. In fact, if there is a mixed mandate and if there is a minority government, you will generally see a higher stance of what is called an office of profit. This is statistically seen across various state legislatures. Now, on the recommendations of the Bhargav committee, eventually a joint committee on offices of profit was set up. And this joint committee on the offices of profit, which is basically a standing parliamentary committee, its primary function is to examine which offices should be given an exemption under the Parliamentary Disqualification Act and to see if there are any untoward exemptions that have been given by the legislature also. Which therefore brings me back to my primary objective. The office of profit as a concept tends to serve two very simple principles. First is that separation of powers must be a non-negotiable to the best of your ability between the legislature and the executive. And second, prevention of the possibility of a conflict between the duty and the interest of an individual who is required to perform the role both of a legislator and a member of the executive, which primarily tends to mean conflict of interest. And as a consequence of this, you have given birth to the idea of what is called office of profit. Now, the idea is, if you look at the international origins of office of profit, office of profit for the first time found mention in the UK scheme of laws, and therefore is a concept that could largely be said to have been borrowed from the United Kingdom. But it is an equally important concept in American and Australian constitutionalism. In fact, in Australia, Article 44, if I remember correctly, in a very explicit form, mentions office of profit. The idea behind office of profit is to simply provide not just a functional parliament, but a parliament which is ethical by nature. In the 1701, if I remember correctly, there was a British law called the English Act of Settlement of 1701. That is where the term office of profit was coined and was mentioned for the first time. And under this English settlement law of 1701, any person who was acting on behalf of the king at that time and was receiving any benefit from the crown should not be a member of the House of Commons. And that's largely where it effectively came from. Now, the UK, of course, is the birthplace of the idea of office of profit. But even in the American Constitution, you would find explicit mentions of it, though comparatively one doesn't have to get into the finer details. When we understand this, we then understand the structure and the functioning of office of profit in India. Now, there are very, very popular cases, and I will go through these cases one by one. But the idea is there are some cases that have to be mentioned. There are some cases that don't. Because office of profit has not been defined, the role of the Supreme Court shoots up, and therefore this can be used as an example of judicial activism. Now, there are two parts to this. First, what are the essentials of office of profit? And two, what are the tests to determine what is office of profit. See, the difference between essentials and test is this. Essentials are the bare minimum conditions on the basis of which you can question a person to be holding office of profit. Test is a minimum number of conditions. If the person fails, then is deemed to have been holding an office of profit. The first condition, the first essentials, are a list of 3 essential elements. I've just given you one case for this. Umrao versus Darbara Singh of 1968. There are 3 conditions. 1, the individual holds an office. 2, it is an office of profit. And 3, it is therefore under the government, and it is under the government of India or the government of any state. Now, the fact that there must be an office of profit, the fact that there must be an office is a very, very important consideration. Now, why is this an important consideration is something that we must very categorically understand. It is an extremely important consideration because unless you hold that office and you receive something for it, and the office is in some form under the supervision of the state, then there is no conflict of interest in the first place. Even the term office has not been defined anywhere. But if you look at Supreme Court judgments, there have been therefore attempts to define what is office. Now, I don't want to get into the technical judgments around it, but a judgment comes to mind, which is the Kathuria versus Surana judgment. Now, it was in this judgment where the term office was defined to be any form of employment, and it is permanent in nature, and it exists independently of the other office. Now, what happened in the Kathuria versus Surana case was also very interesting, though I don't think you would have to write it in a lot of detail, but the case is very interesting. Mrs. Kathuria had won an election. Now, her election was questioned on the grounds because she was employed as a special government pleader for the state of Rajasthan. Now, the court had therefore held that this is an indirect conflict, but the person in question was simply appointed to do some jobs which were independent of the other aspect. And therefore, the court held that this post was not an office of profit per se. 2, the office must be of profit. Here, Section 2A of the Parliamentary Disqualification Act of 1959 must be quoted, where it says, if you're receiving money other than what is called a compensatory allowance, then you would therefore be holding an office of profit. A simpler judgment that comes to mind is the judgment of Divya Prakash and Chandrana, where Chandrana Saab was the chairman of the State Board of Secondary Education, although in an honorary capacity. His election was therefore challenged on the grounds that he was holding an office of profit. He very categorically contested that his election should not be on the grounds of challenge, because he was not taking any money. Although there was a scale of play which was attached to it. Now, unfortunately, the court had to get into this in a fair amount of detail. And unfortunately, the court had to therefore get into the technical elements of this. The court therefore held that because this person did not receive any money, the office cannot be held to be an office of profit. And this led for many further judgments to follow. Similarly, we will come to this case again. This is the case of Hegde versus Karnataka, Ramakrishna Hegde versus Karnataka. In this case, Mr. Hegde was appointed as the deputy chairperson of the planning commission. And it was therefore argued in this case that there was profit attached to the rank, because as the deputy chairperson of the planning commission, you enjoyed the status as a union cabinet minister. And therefore you had allowances, well-furnished accommodation, and so on and so forth. The court held that these allowances were within the meaning of compensatory allowance. There was nothing extra, there was nothing more. In a very, very well-known case called Jaya Bachchan versus Union of India, and Jaya Bachchan is none other than Jaya Bachchan, where Jaya Bachchan was to hold the chairpersonship of the Central Board for Film Certification, which is the censor board. The chairperson of the Film Development Council, which is a very important organization and promotion of cultural and other related affairs. Now, the court held that by being the chairperson of the Film Development Council, there is a pecuniary gain attached to it. Even if you're not receiving it, the fact that you're a chairperson of the Film Development Council means in some form or the other, you're bound to gain something, given the fact that you also come from the film background. And therefore, despite the fact that you were given an equivalent rank of a cabinet and all the perks that come around with it, the court decided otherwise. Which means there is also a fair degree of inconsistency when it comes to judicial interpretations with respect to this. In a way, Supreme Court judgment in Hegde and Jaya Bachchan tend to be at a little bit of a contradiction, but such is the law. The third is that the office must be under the government. Now, the Supreme Court got into a fair bit of detail around this, and this is a slightly complex case. Though I've given you an umbrella case for this and you should be okay with it. You don't need to know these specific cases. In Chandrasekhar Raju versus Pradeep Kumar Dev, a very interesting proposition came up. The election of a primary school teacher in a school which was generally run by the Integrated Tribal Development Agency was challenged. The appointing authority to that primary school teacher was in fact a government officer. And members of the governing body of the school, which controlled the administration, the overall activities, the larger policies, were also officers of the government. And funds were to be sanctioned to the school also by the government. But very interestingly, the court held that while there was government supervision, this post was not one under the government, because it did not directly control the teachers. And that is why it became very, very interesting to understand that yes, it has to in fact be collectively owned by the government of India or any of the government of the state legislatures. It is also very important to understand the nature of control. Now, why is it important to understand the nature of control? It is important to understand nature of control because of A.K. Bhattacharya versus Ajay Biswas in 1985, further reiterated in Dobre versus Dobre, which is an important case that you should know. The extent of government control plays a very significant role in deciding whether this was actually a problem or not. The extent to which the government was to get into the activities of it plays a very important role. And it's not the extent, it is also the amount to which the government can regulate the office. So, continuing with the rest of it, one understands that doesn't matter what the office is, what absolutely matters eventually is the nature of control. Now, moving on, in 1993, the Supreme Court also added a test which was basically pecuniary advantage. Now, the Supreme Court, while acknowledging the idea that there should be some gain, the court also went on to very categorically explain that just because there is a prestige value attached to it, just because there are certain perks attached to it, the office necessarily does not become an office of profit. And the court also in 1958 in Hotilal versus Bahadur added another essential, which was basically regularity of income. Now, originally it was understood that the income has to be permanent and the income has to be recurring. But later the Supreme Court eventually understood that that might be a case, that it might be a one-time award of a certain amount of money. And that itself could therefore be questionable on grounds of office of profit. And then in 1953 in Gulam Chand versus Gulam Chand versus Thakur Singh, the court also integrated the idea of sui juris. Now, the principle of sui juris is that the person who is occupying the office must also be legally eligible and legally equipped to therefore hold the office. Now, on top of these essentials, the Supreme Court also came up with a certain number of tests. Now, these tests are basically 4. And if you want to just use one judgment for all of these tests, like how you can use one judgment for all of the essentials, that is Swapan Roy versus Pradyut Bordoloi. This is a very recent 2001 case. It is in this case that the Supreme Court has basically laid down 4 tests. And the tests are fairly simple. The tests are, first, the government must be the authority appointing the person. 2, the person who's being paid a certain amount must be paid so by the government. 3, there must be sufficient control that the government can exercise over the person. And 4th, if there is an apparent conflict of interest, then the office is in fact an office of profit. So the idea behind this is that you are trying to prevent any form of a loss of integrity in public life. An office of profit therefore tends to be one of the mechanisms in doing so. And the idea behind all of this is that you are trying to provide effectively greater accountability to the executive. And if you can't keep the executive accountable, an office of profit would be a way in which it could be hampered, because half of the people would be holding offices under the state. It would effectively be a problem. Now, this has been recognized by several bodies, by several agencies. And the one body that you can remember is the second ARC. Now, the second ARC has given very categorically 3 recommendations. First, the second ARC says, offices in purely advisory capacities may not necessarily be considered as office of profit. Doesn't matter what the remuneration is. 2, offices whose occupant has executive decision making power or any form of control over public funds, that person must always be subject to office of profit law. And third, if a person who's heading or is a member of an organization where there is close coordination necessary for that organization and the government, then just because there is a close coordination necessary does not necessarily mean the person should be charged with office of profit. See, the Supreme Court has tried to put reins onto this. The Supreme Court has tried to come up with several practices in place that could bring some order in the chaos of office of profit. But what you are looking at is a practical view. What you are looking at is effectively a way to run the government smoothly. Because as much as integrity is important, productivity is also important. Which is why, while on one hand you have separation of powers, you also have checks and balances. And somewhere in the middle is office of profit. And office of profit should balance what is called integrity in public life, and therefore also balance it with productivity in public life. Because ultimately, this is what is going to lead to a far more comprehensive administration and a far more accountable administration. So this takes care of largely our understanding of office of profit. I don't think anything more than this is particularly needed.